number 11.
Item number
11. Lordship, I am for the petitioner. We will be filing our affidavit in reply. 3 weeks may be granted.
Miss
G. Swami.
Telephone.
Yes, Lordship.
Key.
15, 1 6. Yes.
This is started with the master. Respondent. I'm respondent number 5. 5. You have entered appearance recently. Today I submitted the final leave for the home. Final leave. Go through the brief one part time. Mr. DJ Modi. By filing.
Promotional. I don't want. Come on, my lord. Amount has been mentioned here, my lord. 582,556. Accordingly, my lord, I supplied those books, my lord. 31, your lordship will go to the 31, another document. Assistant Director DL, my lord. Your lordship got the from that I said,
100 crore. Now the coordinate pencils of the update.
yes, my lord. Only that on that I could not ask quality.
It's not admission of liability.
My lord.
This is not admission of liability.
Assistant Director Industry, they have received another, my lord. Let them take the instruction, my lord.
Your stage
I am not asking anything, my lord.
is very innocent.
Yes, my lord. Otherwise, I will take. I, I, I take. No.
case 40, my lord, if your lordship goes to the order, my lord, same document, order has been passed. Point out that, yes, my lord. And we have to put the Samse Ali. My lord, there is no mention of Samse Ali. My lord, my humble submission before your lordship is that I file an RTI, my lord. There's no other way. My lord, if it is part of 30, the authority always, my lord, admitted. But this type of strong contractor, my lord. This type of admission is concerned. And on that day, I could not show all these things, my lord. Because your lordship case 31, it was admitted. Giving wrong. Yes, what they say, Miss Bora. Corporation. Big corporation. Do they have any seminar? deviate from that. Mr. FC.
Item 4.
My lord, 2 weeks more time may be granted, my lord. We had approached, my lord, the
Same.
chief engineer, but
Keodin.
not received, my lord, any.
Keodin petitioner, R.R. Google,
PhD department.
PhD, and council, all. 1, 2, 3, M. Bhuya. Agor is the same. 4.
No, my lord.
Item 5.
Yes, Mr. Doctor, what you do?
Land was acquired 6869, Lordship. After 40. Your Lordship has already passed an order that on the date of Hemanto Mandal. It's just affirmed by the division of Lordship. On a delay lessons, Lordship.
Delay and Lessons, 1959.
Lordship.
We have the second Soragat bridge.
Lordship.
So it was first Soragat. Petitioner remembered first Soragat
Soragat.
bridge. So at that time it was acquired.
Lordship.
There is no representation on behalf of the petitioner today on call. Mr. S. Dr. Lawrence,
Standing Council.
Standing Council, Revenue. Revenue is
Question number 4.
4. EU does 5 and 6. A Gayon, CGC 1, 2, 3 are present. In view of non-representation on behalf of the petitioner, on call, the later case, for of justice, belief on extraordinary.
5th. 25. Item 6.
Is requested for the affidavit, my lords.
Okay. Upper
Item 7.
Also, I would request some time, Lordship. Admitted
same
liability.
issue. Okay, same issue. A Ganguly, my S. Borua, SR Borua.
Yes, sir.
You are for
I am for all respondents
all.
also.
Senior government, all.
2 weeks.
Same. Agora is
Additional affidavit also.
Item 8.
May I please, Lordship? The matter pertains to payment of actual billing, Lord.
Contextual bill.
My Lord, though recent admission is not there, but in Lordship will find it pays 34 million. This is the letter issued by the executive engineer, seeking revised estimate, my Lord. And Lordship will find it pays,
Where is your work order?
Overall, Lordship will find it 24 million, 26 million.
What are the-
24 is the
What are the pairs?
security deposit.
See, my lord, even that amount is sanctioned, my lord. Lordship will find the sanction
Security
letter.
deposit, first prayer, second prayer. Third prayer is
In the way back in the 2018, my lord, but that has not been released till date. And final payment of
so
rupees.
you have twofold prayer or what?
Lordship.
Oh, so far security deposit is okay. If they have retained illegally, okay. But what about the admission of liability? About the
Lordship will find it page 35, my lord.
what is the work order?
Work order is page 26. Notice to proceed with
26, 12, 2012.
Lordship, that has been, and 27 is the completion certificate, my lord.
Who has issued?
Lordship, that is executive engineer, under which
But that is not the that is not Tamserali.
and Lordship kindly turn to page 35, my lord. After completion of that work, my lord.
What
In
is
the-
this page 34?
Hardwood, it is the
Engineer.
communication
release of
by
final
executive
payment
engineer
for
for
the
revised
project.
estimate, my lord.
Margaret so and so. Name of the contractor. I don't. Margaret so and so.
11 page is 35, my lord.
Again, executive engineer.
Yes, my lord, this is the letter and Lordship will find in column 2, my lord. This is the petitioner.
But that does not satisfy. You have seen
Yes.
last few cases. The coordinated bench has already started observing it. Unless you get the admission of liability certificate from the head of the department,
Lordship.
court will not proceed. So I am bound by that observation. Otherwise, I had issued notice. Now the situation has changed.
I've submitted repetition in
That will same observation. And this is of 2017. And what about your security
not
deposit?
till date not released. Even that amount is was sanctioned in the way back in 2018, my lord.
That is your money. Okay, that can be only on that point we can issue notice.
Yes.
Not regarding admission of liability.
And I will pursue, my lord, since representation has been submitted to the chief engineer, my lord, for payment along with security.
Since there is no admission of liability statement from the head of the department, you drop this for the time being. We'll
Yes,
observe.
So far as
Only on the security, yes.
Security deposit.
Security interest, if they have retained, that must be released.
Lordship. That I'll obtain instructions, Lordship.
You obtain instruction
Lordship.
on the security. Then you can pursue the other prayers with the statement of liability from the head of the department. I'm Mr. M. Mohanto, learned counsel for the petitioner. And Mr. M. Bhuya, learned counsel
Counsel.
on behalf of Mr. B. Gogoi, learned additional advocate general, because finance, PW both are there
Lordship. Yes, Lordship.
for all the respondents.
Lordship.
So the petitioner was awarded a part of a contract work, quote, development of Margarita Deomali Road in Tinshukia district under Social and Infrastructure Development Fund, in bracket SIDF. And a notice to a notice to proceed with the contract work was issued on which date? Date page 26.
there's 11/10/2012.
11/10/2012. Post of. According to the petitioner, he had completed, he had executed the contract work and entrusted to him. Post of. The petitioner has approached this court by the present writ petition, which two grievances. One, non-release of security deposit amount of rupees 16 lakh 68,015 by the respondent authorities despite execution of the work by the petitioner long time back. And two, for a direction to release an amount of rupees 23 lakh 65,923, which amount, according to the petitioner, has remained outstanding to be paid against the contract work. So, Mr. Bhuya, Learned Counsel for the appearing for the respondent, has submitted that there is no admission of liability to the extent of rupees 23 lakh 65,923 by the concerned authority in terms of the full man's in Kamsarali 2008. Page 1. Close stop. Insofar as the retention of, so far as the grievance regarding retention of the security deposit amount of rupees so and so is concerned, he sought a week's time to obtain unnecessary list the case also. So, you need any copy?
Yes, Lordship, we'll inform.
Mr. Mohanto, Learning Counsel for the find extra copy of the requisition and log in access to it. Yeah, by tomorrow.
Much obliged, Lordship.
February.
Item 9.
Yes, dues now.
My lord, my vehicle was hired, my lord, but the dues
Okay.
not been paid.
Statement.
My lord can find it from page 20, my lord. The bill prepared by the authority,
Bill will not do.
my lord.
Bills are bills.
My lord. Page 9, my lord, paragraph 13 and 14 I have.
That is your statement, sir.
My lord, but their statement has, my lord, what they have done, they have used, my lord, and released my vehicles. My lord can verify, if my lord may be pleased to.
We are not into verification, sir. Where is the admission of liability?
No, admission, my lord.
By the head of the department, who is the authority who had requisition?
My lord, the motor transport, my lord, officer.
He is not the head of the department.
He's not, but he's, my lord, this is not a contract, my lord. This is only an hired a vehicle and bill had not been paid, my lord. Slightly, my lord, with my limited understanding, my lord, there is a distinct.
Yes, Ms. Duff.
My lord, there is no admission as on, apparently.
No, bill had been prepared and it has been put by the authority, my lord. At page 20 is one bill, my lord.
Any forwarding of proposal?
My lord, this is a bill addressed to the commissioner,
Let
my
us
lord.
see one bill.
My lord may be pleased to find is at page, my lord. 20. 21.
20, one
my
bill.
lord, my lord, submission.
What is the original copy?
Original is below, my lord. That
Who
page
signs it?
22, my lord. Here
Who
and,
signs it?
my lord, this signatory is not here, but my lord, in the top, my
This
lord.
is bill. Where is the order?
My lord, the order is not there, my lord.
Huh?
Order, they have done it so casually, my lord. This is the system
Now,
going on.
I think I have seen in many of the petitions orders.
No, my lord, here in my case, my lord, what they have done, they have even hired when they hired, my lord, no document had been executed. They have used my vehicle for a period of 91 days, my lord. And they have admitted that per day, I am entitled to the amount, my lord, 2,091 rupees, my lord. 1,079 rupees, my lord, into 91 days, my lord. So, my lord, my respected friend can verify, my lord.
Kind of vehicle.
These are the documents available with me, my lord, nothing else, my lord.
Yes, Ms. Das,
My lord,
whether it stands in a different footing.
my lord, I don't think so, but my lord, there is no such, my lord, admission, and my lord, it is his bill he has submitted. There is no such order also, order.
Bill has
Well,
not been,
earlier I used to issue notice,
Ah.
even if, but now my coordinate bench has observed, so
That has
he
already
has
been.
taken a stand, so I cannot
my lord,
again take a divergent stand, again
Doesn't
open
matter.
another line.
Yes.
That
Doesn't
is
matter.
the difficulty now.
My lord.
my lord, my respected friend can take instruction, my lord. If I am entitled, my lord can consider, or my lord, we
That is, every case can be disposed of.
my lord,
Is it not?
my lord,
Yes.
That word consider
my lord,
is the most powerful word.
my lord. Consideration, my lord, many times goes against also, my lord.
Oh, 80% times.
My lord. My lord, may I
We
humbly,
have seen.
my lord, may I humbly pray, my lord. Now, I have inquired with the petitioner also, my lord, that any other document lapse, my lord. But
Now
he
you
is,
get a statement. I have observed
My lord.
that he will approach
my lord,
the concerned
my
authority
lord,
as regards that.
my lord, not paid, my lord.
I'm granting time so that you take this order,
My lord,
get an order. State.
Yes.
I think that will help you
my lord, that I can do.
to an extent.
My lord,
That court has asked for it.
my lord.
Okay, heard Mr. A.R. Hunyan, learned counsel for the petition. And Miss Udas, learned edition, and the senior government advocate for all the respondents. So it is the case of the petitioner that he is the registered owner of a vehicle bearing registration number AS01EK 9261 Billion Packet Innova. Probably subject vehicle or so. The petition has stated that the subject vehicle was requisitioned by the office of the respondent number 2,
My lord, Commissioner
Ah.
of Police, my lord. My lord,
respondent number 2, to the
motor
concerned motor transport
officer, my
officer
lord.
from time to time with the assurance that the higher charges
My lord,
for the period of hearing
my lord,
would
90.
be paid
My lord,
to the petitioner as per the prescribed rate fixed by the government. And to stop. Though the vehicle, subject vehicle was always released after the period of hire was over, but the bills submitted by the petitioner have remained to be processed and paid till date. First of, according to the petitioner, the total amount Sir, what is the amount?
my lord, 2 lakhs 8.
Where is that?
My lord, is at page 32, my lord. Grand total rupees, my lord.
The total amount
2 lakhs 832 rupees, my lord, including GST
uh,
also.
that has accumulated as outstanding from Amazon date is 2,832,000. Paramis task. Done its preparing for the response. Submitted that. The petitioner has not annexed any statement from the head of the department. Has not any statement admitting the liability to the extent of this so and so towards higher charges of the subject vehicle in terms of the full and in so and so. Those of Mr. Bhuya and council petition submitted that no approaches were made earlier for such statement. No response has been received by the petition till date. So however, as such statement is a necessity, you would approach again. You would approach the concerned authority again for issuance of a statement of liability. So, in view of the above permission made by Mr. Yeah, let the case again, you
Mal.
so as to enable a petition
Right.
to approach the concerned authority as regards a statement of life, statement of admission of life.
Mal.
I think that might help you.
Mal. Obliged, my lord.
Supplementary list, item number 27.
Yes.
My lord, this is
Yeah.
the tender, my lord.
Huh?
Initially, my lord, the tender was against the private respondent number 4. He was the contractor, my lord, who was awarded the work.
Respondent number
Private
6.
6, my lord.
6.
So 9/12/20, the work was
9/12.
terminated. And that is annexure 1, my lord.
Annexure 1.
Yeah, the work was
This is
terminated.
respondent number 6.
Respondent number 6, my lord.
The above work was awarded to you and game is stopped.
Because the work was completed only 40%, my lord.
The power of so and so. So and to terminate the work, fundamental breach on behalf of the government. Give you notice to terminate the work. You so and so. This is yes.
Yeah, then, my lord, by annexure 2, the work was allotted to me, my lord. The petitioner, lordship may see at page 28, my lord. The type copy, my lord. Of an amount of rupees 3,74,33,991. Then I've been issued, my lord, by annexure 3 to commence the work, my lord. That is at page 30, my lord.
Yes.
This was challenged by the respondent number 6, my lord.
What was challenge? Termination.
Termination, my lord. Termination plus issuing the balance work to me, my lord. So at page 33, my lord. Now operative portion, my lord, as page 51, my lord.
If you
Para page 51, para 51 may be seen, my lord. In view of the, as a lordship got it. In view of the above discussions, this court is of the opinion that while the first challenge pertaining to the termination of contract is not liable to be interfered with, the second part aspect of allotting the balance work to the respondent number 6 would require certain intervention from this court, as it involves huge amount of public money and the work in question is
why? Why? What is the reasoning in the previous paragraph? Why is on the second aspect
yes.
requires certain intervention? Why? What is the reason?
Well, because there is some anomalies in making the payment, my lord.
Anomalies.
Because the main fact was that, my lord, he had got the word on 9/2/2001 and he completed the work on 24/3/2001, my lord. So that there is
Petitioner. 1 minute. No advertisement.
no. Huh? Okay, the advertisement was there, but there was some technical.
And release of 1.91 crore within 2 days.
Within 2 days, the bill was
I don't
there,
know,
my
page
lord.
49.
No, page
Para
49.
45.
Yes. Furthermore, the
It
concern
is submitted that there was no advertisement prior to the said allotment. A huge amount of rupees 1.91 crore was paid within 2 days. Let us see what is the reasoning court has given. That is the submission. Startling revelation. Revelation allotting the balance work after observation made gave importance. Samir Ali preparing a running bill during inquiry. Observations are made. Measurement was recorded. Date of commencement.
That was the one of the, my lord.
Date of last measurement. Signature running bill. Passing of the so-and-so. Okay. Some
Yes. Because
certain
of the
intervention, yes.
short-
Please come to page 51, paragraph 51.
page 51, my lord.
Paragraph 51.
Paragraph 51.
Third line, third line.
Third line, my lord.
Second aspect.
Second aspect of allotting the balance work to the respondent number 6 would require certain intervention from this court, as it involves huge amount of public money, and the work in question is undoubtedly of immense public importance. However, since the question of facts are involved, this court cannot play the role of primary authority. At the same time, there being a glaring anomalies in the said allotment, as would reveal from the fact-finding inquiry of the additional chief engineer PWD roads dated 6/4/2022, appropriate action be taken against the hearing officers, more particularly respondent number 5, against whom specific allegations have been made, which are also substantiated in the inquiry report. Appropriate steps may also be taken against any other officials involved, including the beneficiaries. In view of prima facie finding of in the inquiry report dated 6/4/2002, it is needless to state that the action to be taken has to be strictly in accordance with law by giving a fair opportunity to the persons arranged, my lord. This was the order.
Okay.
Then subsequently, my lord, two order was issued, which we challenged in a writ petition, my lord. That is 5/6/2025. But this report was not furnished to us. But ultimately, my lord, lordship may come to page 54. Last para, my lord, considering the above. This is-
54.
Yes, page
Ah.
54. Considering the above, I am requested to kindly take the following actions. This is written by my lord, Secretary to the Government of Assam, to the Chief Engineer, I think so, to the Chief Engineer, my lord. So first, my lord, take action against Gulzar Hussain Chaudhary, that is the petitioner, my lord, for his involvement in forgery and misappropriation of government money to the tune of rupees 1.91 crores, and to recover misappropriate amount. Number 2, pass a necessary order making the work order number so and so dated 20/2/2021 issued to Gulzar Hussain Chaudhary for the balance work as null and void. C, the necessary action for completion of PMGSY package number so and so by the original contractor Shri Mansoor Ahmed following the procedure, and to submit a report as to the involvement of other officials involved in the so and so. So thereafter,
What happened to the judgment? Attain finality.
yes, the RTPL was preferred, my lord. The RTPL ultimately
It will be prepared by whom?
by him, the private respondent number 6.
Mansoor.
Yes, Mansoor, my lord.
Okay.
So they have lastly withdrawn the appeal, my lord, on the plea that the work has been allotted to them again. That order is there, my lord. Lordship may see, my lord, that order, RTPL order, my lord, at page 121, my lord.
121.
121.
Just a minute, just a minute. No, read-appeal order.
Yes,
Where is the read-appeal?
121, my lord. That's from one.
It is different.
Sorry, 116, my lord. Sorry. 116 and
116.
116,
Mansoor Ahmed.
118, my lord. Starts from 118.
We have heard.
We have heard Mr. So-and-so, learned senior counsel for the appellant, and so-and-so, learned counsel for government advocate, Assam for the respondents. The appellant was awarded a contract for construction of a road under so-and-so. He carried out substantial construction, completing approximately 5.3 kilometers. A road out of total 5.43 kilometer, which fact was never disputed. However, during the period when the pandemic set in the work had slowed down, and by the time the contract period has expired. It was the case of the appellant that despite several reminders to the respondents for extension of time for concluding the contract work, no order was passed. However, to the dismay of the appellant, sometimes in December 2030, his contract was terminated, saddling him with penalty of 20% and with a direction to cease the work immediately. The order was passed without any notice to the appellant. The order presumably was passed by an executive engineer and not by the chief engineer, who was the only competent authority to pass such order. This submission of the learned counsel for the appellant was contested by so-and-so learned senior government advocate that the power to take decision in that regard had been delegated to the executive engineer. Nonetheless, when the matter went before the court, the learned single judge found no folly with the decision of the respondents in cancelling the contract of the appellant. However, on account of various startling facts having been brought to the notice of the court by the appellant regarding the selection of the new concessionary without indicating the portion of the work which was completed by him and release of a huge amount of money towards the bills raised by such person without the work having been started by him, an inquiry was directed by the learned single judge. Pursuant to the inquiry, the allegation level against the appellant was found to be correct. The respondents, in their wisdom, recalled the cancellation order and directed the executive engineer to entrust the balance work to the appellant by communication dated 7/8/2005. The executive engineer, by communication dated 19/8/2005, asked the appellant to mobilize his resources and intimate the respondent about the date of actual resumption of work. The appellant now is in process of mobilization his resources and would make effective correspondence with the respondent.
Salary 7/8,
So
2025.
lastly, my lord, in view of that, the appellant seeks withdrawal of the appeal.
Where is 7/8/2025?
17,
7/8/2025
17/8 is at my page 61, my lord.
and 19/8.
1980 as page 63, my lord.
Okay, so somehow it has been diluted
Correct. Now, my lord,
in their wisdom.
yes.
So by Gogoi, using wisdom, recall
Now, I want to
Gulzar Mansur was allowed to resume his work.
resume.
Meaning thereby, because of all the startling revelation, whatever, that remained as like that, fact finding input.
Now, lordship,
Now-
I'll bring, I'll now short, my lord. I'll bring two affidavits filed by the government, my lord. Lordship may see one affidavit filed by the chief engineer. Now, page 79 may be seen, my lord. Page 79. This is the affidavit filed by the government, my lord. By chief engineer, my lord. Now, para 10 may be seen, my lord. Page 79.
Page 79 is the affidavit.
Affidavit, my lord. One of the
Para
affidavit.
10 is
Para 10, my lord.
96.
Yes, last 6 line from top, my lord. Hence, the work was terminated, lordship. Para 10.
Para 10. Page 96.
Page 79, my lord.
29. Okay, 17. Para 10.
7th line, my lord, from the
Hence,
the work was terminated at his risks and costs, imposing 20% penalty as per tender clause number 25 of GCC. The balance work had been awarded to the respondent number 6 by e-tendering process of so-and-so on 8/8/2021, and the contractor and the respondent number 6 started the work with sufficient men and material and performed 90% progress of the part and 70% progress of RCC so-and-so. Now, para 14, my lord. Page 80. That as regards the statements made in so-and-so, the opponent denies the averments made in the petition.
para 14.
Para 13, my lord. Paragraph 30, para 14, my lord.
Yes.
Now, the petitioner and humbly begs to state that the averments made by the petitioner is absolutely false and fabricated. The petitioner has intentionally suppressing the actual facts to take advantage. The contractor of the balance work, that is respondent number 6, has taken over the site of work in question on 9/2/2021 and after having LOA on 8/8/2021, and the respondent number 6 has started the work by developing sufficient men, machineries and materials and achieved 90% progress of the work within 24/3/2021, engaging laborers to do day and night works. The SQM had also visited the site and satisfied with the progress and quality of the work. Thus, answering respondent number 4 hereby denies all the statement made by the petitioner in the above stated paragraph. The respondent number 6 was asked to start the work immediately, considering the time-bound flagship of the project of so-and-so. Now, this is the affidavit, and the next affidavit in the writ appeal filed by the chief engineer, my lord. Lordship may see at page,
So far, this affidavit is concerned, this was filed in WBC 2243.
yes,
2243.
yes. Now, the writ
That,
appeal,
a judgment has been delivered, rendered there.
yes,
Right.
no, I want to show that, my lord, that work has been completed, my lord.
But it was followed by some fact finding. When, when it was filed?
In the writ appeal, my lord.
No,
Lordship
no,
may
in
see,
the petition, when this affidavit was filed?
it was filed subsequent,
September 2021.
yes.
When the judgment was delivered.
Judgment was delivered on, my lord, 13/11. The 30/11/2022, my lord.
Where is the affidavit?
And
Mention of affidavit. Additional affidavit.
it is September 2021, my lord. And judgment was delivered on 13 November, my lord, 22.
And this affidavit was submitted when?
When September 2021, my lord.
Then there was additional affidavit also.
Yes. And lordship, very most interesting, my lord, in the writ appeal, my lord, lordship may see they filed an affidavit, my lord. Lordship may come to page 112, my lord.
112.
112. This is on the writ appeal, my lord.
Writ appeal.
Writ appeal, my lord. That is writ appeal 397 of 22. It starts from page 101. Para 24 may be seen, my lord, at 112. That with regard to
Yes,
the para 24, my lord, of page 112 of the writ appeal.
Para 24.
My lord. That with regard to the statements made in paragraph 42 of the writ appeal, the deponent states that as per verification, present status of balance work under PMGSY package AS 13278 done by the respondent number 6 is found complete in all respects. So now, what happened, my lord? We filed a writ petition, my lord. The Honorable Court passed an order which is at page 13, my lord.
Page
13. Guljar Hussain Chaudhary, he filed a writ petition, my lord. Page 13. Lordship may see the page from 104, my lord.
Page 30.
Page 113, my lord.
130. That is after writ appeal or what?
Yes, after writ appeal, my lord.
Yes. For what you have preferred that writ petition?
No, my lord, writ appeal.
What is the relief sought in the writ petition?
Yes, relief was sought for to, there was a order passed by this court, the authority, my lord, 5/6/2000.
Let us see the writ appeal order
Writ
once again.
appeal. Writ appeal order is at page 121, my lord.
121. Just a minute.
No, sorry, 118, my lord.
It was on 11/11/2025.
11/11/2025.
And this man is a party? He was a party?
Yes,
He was represented?
yes.
Represented or not represented?
Represented, my lord.
Represented.
Yes, lordship may see. We have heard
In-
so-and-so senior counsel for the so-and-so and senior counsel so-and-so, the appellant is reachable to Hasin. Reachable?
Huh? He is there, Mr.
He is
D.P.
there.
Bora. Yes. That
Yes.
was 11/11/2000.
11/11/2025. And
And your repetition was with regard to what?
with regard to matter, we have because courses action taken by order dated 17/6/25 and 7/8/25 against that order, we move the High Court, my lord. That
Which is 7/6.
lordship may 7/8 chief engineer issued that balance work is illegal, my lord. because my work was held to be illegal. So we challenged that order. Plus,
But that was also challenged by the Guljar.
Guljar earlier. Mansoor earlier, my lord. Mansoor has challenged the writ petitions order. Writ petition.
No. Initially, he challenged this order. In the writ petition. Let us see the writ petition, his writ petition, sir.
Page 38, my lord.
You know, okay. You challenge this 7/8/2025 and 19/8/2025.
7/8/25/19. So the first is balance work held to be illegal. And second, the resumption of work from us, my lord. The work was issued to Mansoor at price of rupees 5,17,50,557. So there, my lord, the court has passed this order, my lord, that page 114, my lord.
No, some 5/6/2020. 17/6/2020. 7/8/2025.
17/6/2025, my lord.
19/8/2025. 7.
Three orders, my lord, letters of the authority, my lord. We have challenged that 17/6/2025 at page 58, and 7/8/2025 at page 61, and 19/8/2025 at page 63, my lord.
This writ petition by virtue of this writ appellate order, things have changed. Scenario has changed because you moved the writ petition 3/9/2025. No coercive action.
Yes, no question.
But by virtue of this 11/11/2025, the scenario has changed.
Letters.
Oh, 118. It was subsequent to that, right?
Understood.
And
But-
it is not that it was an ex parte against you. You were there.
Lordship will see one thing, my lord. This is because this 7/8/2005 and 19/8/2025, because work has been allotted to them, so that's why they have withdrawn this. Subsequently withdrawn the. And that was
Somehow or
reflected in the
other,
writ appeal.
somehow or other, they exercise their wisdom. And the division bench, it had received judicial imprimatur of the division bench. Have you seen the situation? Just
No, I'm saying.
see the respondents in their wisdom recalled.
Because
In their wisdom.
ultimately, my lord.
Just a minute. The single judge has set aside the termination. Oh, sorry. Has approved.
Approved.
Right. That is
Termination.
That is
plus
a judgment.
The second part,
Judgment. And second part is inquiry.
inquiry.
So far as this Mansoor's termination, it was approved by a single bench. Right. That termination was correct.
Right.
Now, as a super judicial authority, PWD exercise their wisdom, sitting over the decision of the single bench. Right?
Right.
But somehow or other, it had received stamp of approval
No, but
from 1 minute from the division bench. And what are the things within the swipe of the carpet? I have to see my limitation also.
Right, Your Lordship, absolutely correct.
Mr. Gogoi had said over single judge's judgment, I exercise my wisdom and I allow him to leave aside. Court has passed a termination order, approved. I am permitting him again. Right. And in their wisdom, and that had received approval from the division bench.
That
Right.
will-
Now, as a result, this Mansur is under a cover of the division bench. Have you understood?
Yeah, Lord, yes.
Now, what is your case now?
Now-
That order was prior to 3/9/2025, was prior to that. That is why I said that whether it was or the order was passed in your presence or not.
Yes, it was passed.
It was passed in your presence.
But Lordship will
Division
see.
bench order.
No, but division bench order, Lordship will see ultimately what happened, my lord.
Now why you have come now?
Ultimately, what will happen, division
Now,
bench order.
why you have come?
Last 120 may be seen, my lord, page 100, division bench order, my lord. The appellant seeks withdrawal of this appeal, my lord. So it is not that on merit the court has passed the order. Withdrawal of the appeal, permission granted according to the appeal is dismissed as withdrawn. So division bench order will not govern here, my lord.
Now what remedy you are seeking before
Yes, Lordship may-
single bench now?
Yes, right, my lord. Because that earlier petition was also my pending, my lord. We filed a new fresh petition because now 2 letters has been issued. Now my question is before going,
Which letter?
page 121 and page 123.
121.
1 and 123. Lordship, may I read, my lord? Para 3.
Formal letter to chief engineer.
Yes, this is letter by Deputy Secretary of the Government Assam to the Chief Engineer, then Chief Engineer to Executive Engineer, my lord.
One minute. Yes.
Yes. Now, my
It
lord,
is 121 by 121.
121 and 125, my lord. 123, sorry, 123. Annexure
What is the
16. This is
effective
my
part? Where is the effective part?
effective part, my lord. Second line may be seen, my lord. Further, you are directed to submit an affidavit of for WPC number so and so before the Honorable Guwahati High Court appraising the factual position of the case, seeking permission to proceed with action as per letter dated 17/6/2005, liquidation of forfeiture of security deposit and purpose security so and so. I appreciate the urgency of the work, my lord, but at this stage, my lord,
Huh, so,
Lordship-
permission, they would require permission.
permission. Now, my-
In 4887,
yes,
2025, it is not final. Para 10, you are requested to submit an affidavit in WPC number so and so,
His Lordship may,
and apprising the court of the factual position of the case and seeking permission to proceed with action as per government letters dated 17/6/2025 and 7/8/2025 against Sri Gulzar Hussain Chaudhuri. Right. It was a direction to Mansur.
yes, and first para, my lord, resumption of work, my lord. First para.
But that is subject to permission.
Mansoor, no.
If I have understood correctly.
Just I'm reading it myself for my satisfaction, my lord. With reference to the above letters and the recent government letter number so and so, you are asked to take action and direct the contractor, Mansoor Ahmed, to resume the execution of remaining work so and so. Now, my question is that, my lord, authority has admitted that the work has been completed. Now,
This is a letter from the government to the chief engineer.
if he is resumed with the work, my lord, same work which I have completed, he'll show that work, my lord. So let there be a joint inspection.
No. As on that the situation has not come. See, this is a letter from the government to the chief engineer.
Then chief engineer to the executive engineer, my lord. That
And
page
let us see.
123. Page 123. And he has been asked to complete the work also, my lord.
This
But-
is wrong. Last page is wrong, Mr. Gogoi.
Well,
See the government's instruction to chief engineer.
para 10.
Para 10. No coercive action, one order is operating.
No, that's why they say that you file an affidavit, clarify
No.
everything.
No, last page. Or he is also
No, you say
No,
you
second
file an
para,
affidavit,
second
clarify,
para.
yes.
second para.
My lord, say,
My lord, may I clarify, my lord, on this?
Second part is clear that before the Guwahati Court apprising the factual position of the
In WBC number so and so.
that
to proceed with action as per letter dated 76 for liquidation forfeiture of security.
And Lordship will say 17.6 at page 60.
1 minute.
then,
No, this content is wrong.
17.6
then
is.
page
No,
126,
no.
please, my lord.
Please see the government's wisdom and chief engineer's wisdom.
My lord.
Para 10, you are requested to submit an affidavit, right? Meaning thereby chief engineer.
My lord.
Before the Honorable Guwahati High Court apprising the court of the factual position of the case, right?
My lord.
And seeking permission to proceed
Yes.
with action as per government letters 17/6 and 7/8. It was directed
Because
to
there
the
is
chief engineer.
Yes, no coercive.
Chief engineer.
My lord.
And against Sri Gulzar Hussain Chaudhuri.
My lord.
17/6 and 7/8. What is that?
Page 60 and 61.
And so many.
Against, my lord, these two, my lord, letters, the petitioner approached this honorable court with this writ petition number
No,
4887 of
ultimately,
25.
division bench said nothing. It was withdrawn.
No, my lord, Lordship will kindly appreciate this.
Your wisdom remained.
Yes.
Your
No,
wisdom remained.
Even on, my lord, one more point is there, my lord. The work was allotted to Mansur, who is the respondent number 6 hearing. It was terminated. And the balance work was allotted to the writ petitioner hearing. Challenging his termination as well as the allotment of work to the present petitioner, Mansur approached the honorable court. He was the first writ petitioner
Yes.
in this present list. There, my lord, his termination was not, my lord, interfered with.
Yes.
But the allotment of work to the present petitioner herein, who was respondent number 6, was interfered with. Now, my lord, the writ petitioner herein, my lord, he has never challenged, my lord, that part that his balance work, what was allotted to him, was, my lord, which has been set aside by Learned Singhuja, he has not challenged it. So, admittedly, my lord, he has accepted it, my lord.
Singhuja said some revelation of irregularities from the fact finding
Yes.
inquiry report So you proceed further,
my lord.
right?
Yes.
You proceed further. He did not make any comment because termination was correct. Now again 61.
No, my lordship will see.
61. Let us go by the timeline. Otherwise, I am
Page 56, lordship
I am
will see,
confused.
para 51. In view of the above discussion, this court is of the opinion that while the first challenge pertaining to the termination of contract
I'll
is not
again-
liable to be interfered
I'll-
with,
Let us see. There are 4 material documents.
Yes.
One is 17.6. Where is that?
page 60, my lord.
Yes.
Second aspect of the
17.6. This is to this petitioner, right?
my lord.
Recovery of illegal payment.
So that was states. They stated no coercive action.
Fixed deposit received. Performance security. Forfeiture.
Yes.
Then fixed deposit received. Amount deducted from bill as security deposit. Therefore, understand is due to forfeiting. Okay. This is 17.6.
Then my
Then
lord,
is
Page 60, my lord.
the previous page, my lord, page 58.
Page
Is my
61.
lord,
previous page is what?
it is my lord dated 5/6/25. Which was under challenge, my lord. And 7/8 page 61, my lord.
17.6. 17.6 is forfeiture, security deposit, performance security against Gulzar. Then what is 7.8?
7/8 is page 61.
61, my lord.
Gulzar. Notice to proceed declared null and void. 7.8.
my lord.
Then what is 19.8?
19/8, page 63, my lord.
19/8, my lord, is
That
the,
is to Mansur.
yes, it has been issued to monsoon.
So
Probably this was placed before the division bench. The balance work has now been
It is
allotted
by
to monsoon.
Mansur.
Yes.
Appeal was by Mansur regarding his
Upholding the
cancellation of
termination order.
war.
Yes.
He was maybe he was concerned with, but his interest was for resumption of war,
Yes.
right?
Yes.
And by this he has gathered
That
some
part, yeah. Yes. But my lord,
something.
yes.
And this was after the single judges.
My lord.
Writ appeal was withdrawn, meaning thereby single judge's order remained, right?
Mm.
Termination remained. So then wisdom prevailed.
Wisdom was, my lord, it was placed before
Wisdom
the,
prevailed by this letter of the executive engineer,
My-
not even by the chief engineer.
my lord. Probably in consultation of the chief engineer, he will issue it, not that, my lord, on his own he will
No,
issue.
I am not. It is not there. I am directed. I am directed to inform you. Or this is the approval of the.
Nothing is there, my lord.
Nothing is there. Otherwise, indication is just I am trying to find out the facts.
Yes.
Without the facts, it is very difficult. So wisdom prevailed, and you asked, executive engineer asked, but I think it has then after withdrawal of the writ petition, this government writing. Let us understand. I am direct to refer to the subject. Wherever state directions were issued to the chief engineer, right? Government letter 5/6/2020. Please 5/6/2020.
Page 60.
Is 60. No, that is 17.
No, it is, my lord, 58 and 59.
8 and 50. No, that is also 17. 5/6.
Yes. 58, 50.
This is by Deputy Secretary. There C. Page 57. C.
My lord. Take necessary action for very little. Completion of the PMGSY package number so and so by the original contractor. Mansur
What
Ahmed,
is following new procedure?
you proceed.
Is there any reference to the judgment?
Yeah, yes, it is there.
Yes.
In the very beginning of the letter, it's so. In fact, my lord, this particular letter is already under challenge in the earlier writ petition filed by the present petitioner. This is pending before the honorable court. Page 104.
Then come to page 121, paragraph 4.
Further, in the writ appeal by 397 of
Mr. Gogoi,
My lord.
let us understand slowly. Further in writ appeal number so and so, Honorable Division Bench of the Gauhati High Court had order dated 11/11/2025. Entirely observed that pursuant to the inquiry, the allegations were found to be correct. Right?
My lord.
This part is okay. Now next, and that the respondents had recalled the cancellation order, wherefrom the division bench had observed. And directed entrustment of the balance work to the appellant.
No, it is there, my lord.
No.
They say, lordship will say entirely observed that. Based on the submission made by the writ appellant, that is Mansur, this was recorded, my lord, by the division bench and said that, my lord, it can be withdrawn now.
thing as such has been recorded by.
Lordship will see the last second para.
So the
On the
instruction.
respondents in their wisdom recalled the cancellation order and
In this,
directed the executive
cancel-
entrust the balance work to the so-and-so. The executive engineer by so-and-so asked the appellant to mobilize his resources and intimate to the respondents about the date of resumption of work. The appellant now is in the process of mobilizing his resources and will make effective correspondence with the respondents regarding the date on which the work shall be resumed and the time span when it would be completed. In view of the state decision of the respondents in entrusting the balance, permission granted and actually instead of my lord observed, it should have been recorded. It is recorded in the order.
No, every word carries a meaning. He is putting something into the division bench. Para 4, that is why I have asked you. He should have said that correct. Full stop. Third line, further in so-and-so, by order entirely observed that the person to the inquiry, the allegation were found to be correct. Okay. That is observed. Now, that the respondent has recalled the cancellation order. Where is the approval of the division bench?
Yes, that's why I said it should have been recorded, not properly worded, my lord. It should have
Not
been
properly worded means he is a man in the category of deputy secretary. Is it not?
recorded. Should not have
He is
been
the government.
observed, my lord. It should have been recorded.
He is the government.
Because statement of the appellant was only recorded without any observation from the court.
Statements of respondents were recorded.
Yes. Respondents, no, my lord,
No.
of the appellant. They said that now it has been allotted,
No, no.
re-allotted to me.
No. page 119. It is you. The respondents in their wisdom not appellant. It is your wisdom by which you have recalled the order in spite of the termination of the work order
My lord.
By the single bench.
approved by the single bench as well as division bench. Then appellant said, okay, he got the handle. Next para. Now he in the process of mobilizing his resource.
No, my lord, it is not recorded that it is a statement of the respondent. So who has submitted this pursuant to his
I
wishes?
don't know.
They say respondents in their wisdom. It has not been mentioned
Recall
that
the
respondents have
cancellation
made a statement.
But who is there? Senior government advocate. Senior government advocate is there representing the state. And if this statement is recorded in presence of the senior government advocate, then this statement would be attributed to whom? To the senior government advocate. And if that is a submission, then appellant would be very happy. Is it not? Then he is come to pay after paragraph.
Because my lord, this order was passed on 11/11.
121.
Because the learned single judges said that you continue with the inquiry, proceed with the inquiry.
7, 8. 7, 8. Seven, 17. So what is the due procedure? Once termination has been approved by single bench, and on the basis of inquiry, division bench has said allegation was correct. So termination was being thereby correct. So resumption of contract work as per
No, not my lord.
1908
The
2000.
inquiry, my lord, whatever was conducted also looked into the aspect, my lord, whether the termination was correct or not. Maybe, my lord, at the behest of some official, my lord, in
No,
order to
that is why
accommodate
I
the
have
present
must-
petitioner.
Yes, please, this one, the first government letter.
Yes, it's
I'm
part.
trying to understand the
Yes,
facts.
page 27, lord, you will see.
Come to page 56.
56, para 51, my lord.
Page 57. Considering the above, I am directed to request you to kindly take the following action. Page 56. This was much after the single bench judgment.
Yes, my lord.
Termination at that point of time.
Yes, my lord.
Lord,
You will see one, my lord, in para 56, down below, one it says, my lord, illegal, page 56, my lord, this letter dated 5/6/25. Last one, my lord, illegal cancellation of original contract, that is of Mansur. No,
No.
not very.
Which page? Which paragraph?
56, my lord, that letter dated 5/6, letter dated 5/6.
have been identified,
Yes.
right?
Measure
Identified.
Identified. It
So-
says, first one says, illegal cancellation of original contract. No mandatory notice were served to the original contractor as per clause so and so. Force entries were made in the peon book. These are serious offense, my lord. From this particular inquiry, it came to light that, my lord, in order to, my lord,
It was submitted by the then. Is 57.
my lord.
Is this his judgment? The aforesaid, after 567, the aforesaid fact suggests that the entire reallotment process, yes, this is regarding Guljar,
Yes,
right?
these are, my lord.
Process was marked by forgery, cheating, and gross procedural violation. Okay, accepted,
Lordship.
right? 100%. Next,
The original contract was never legally terminated. Payments were made.
this is made on this, observation is made on 5/6/2025,
My lord.
when the single judges
After passing of the, yes. Yes, after the time, my lord.
judgment was already in force. Once again, let us see the observation. Light here and there, again, it will be to the court. Everything will be attributed to the court. That is why I am looking into it.
My lord, my lord.
Page 51, para 51. First two line.
In view of the above discussion, this court is of the opinion that while the first challenge pertaining to the termination of contract is not liable to be interfered with,
So, original contract is not liable to be interfered with.
termination.
Then this man at page 57, the original contract was never legally terminated. Is he sitting not over a judgment of the single?
But this may be, my lord, a point. But
No,
is
this
not
maybe no, this is serious issue.
No, my lord.
Then what follows?
Yes.
What follows? Payments, let us leave Guljar. Let us leave Guljar for a time. I am accepting your position that all forgeries. All forgeries.
Yes.
Now I am serious with the disregarding the observation of a single judge.
Single judge, my lord.
You answer to that first.
Payments were made in the new to the new contract.
Okay.
On the
All
basis of-
fours, 1.9 crore taken away. Okay, let us assume. Then considering the above, because it flows
My lord.
from that observation, I am directed to request you to kindly make the following action. A, B, and D, Guljar. C is Mansoor.
Yes, my lord. This part, of course, my lord, since my lord, it has been now upheld by the learned single judge. Subsequently,
And also,
can we?
division, at that time, single judge judgment was in force.
Yes.
After 11/11/2025, the division bench judgment came into scenario.
Order, my lord. Yes, that order of the division bench.
Then your wisdom again, this wisdom,
Yes.
which was observed, that was reiterated in page 120.
No, I understand, my lord. That para 4. Para 4.
That is why that trace is here. Never legally terminated.
So they found that, my lord, finally,
Who?
that the authorities, my lord, on inquiry, because they are allowed to
That
continue.
cannot be now.
Now, yes.
Is it? You are,
That should have been
you are additional advocate general of the
Yes, I
state.
understand. On that
Are
point,
you
there
in the
should be
side
some-
of the chief engineer or as an officer of the court?
But that part I
My
understand. But, my lord,
simple question.
how the present petitioner is aggrieved, my lord, that's
We'll
one
look into it.
Yes. What?
But
Because this
that
is not
how can
against
no
him.
once a terminated contractor
and my lord, by who? My lord, the one for whose for my lord
and
facilitated this, the
judicial
present petition-
judicial imprimatur and termination is legal. Meaning by thereby he defaulted.
my lord. That is the allegation.
That
was
is the allegation, and
Yes.
it received judicial imprimatur not from the single judge but also from the division bench. Right.
Lordship.
Then, whether this wisdom
Yes.
was correct, then even we are not required then. I think, is there any necessity of the court exercising 226 power? No, not required.
Not required. Well, yes.
No.
Going by.
The state can go on.
No. Under
Judgment,
that, no.
all these are papers.
No, my lord, regarding the
Right.
present petitioner's part.
Then what does he do?
My lord.
He may not have this, but when this comes to the notice of the court,
Right.
whether the court can close its eyes. That is
part
the question.
I cannot, my lord.
That is the question, at least I
make
am
any
asking
submission on
myself.
that point. Yes, my lord. But my lord, it is not properly worded, my lord, that I would say, my lord. But it's not that,
No,
my
no.
lord, there is some, my lord,
A defaulted
malafide
contractor.
intention of the authority to facilitate the writ petitioner, earlier writ petition.
How to do it?
Yes, they
Suppose
would have
a
preferred
work
an
order
review,
is terminated.
They would have preferred a review or, my lord, an appeal.
No, they
against
could
it.
have
Yes, the remedy was there. my lord.
to
Till then.
retender.
Yes, ma'am. But my lord, in the last para, they have at least stated that you now pursue it by filing affidavit in the writ
No,
petition.
that is.
It's not that, my lord, probably, my lord, that intention was not there. It is not properly worded. At least, my lord, in para 4 part, my lord, observed part.
I am trying
But,
to
my lord,
understand.
reviving that,
You
yes,
have to submit an affidavit before the court, apprised in the court of the factual position of the case, seeking permission. No, I have read 17/6/2025 and 7/8/2025
Yes.
is against the present petitioner.
present petition.
So they sought
Yes.
permission to proceed against him,
Yes, my lord.
but somehow
Yes, that will have to be looked into
With
because
this-
it's there in the record now.
whether a terminated contract can be given the same contract work without retender.
Yes,
He is forgery full, everything.
my lord.
But how you have worded your case? Can you sit over a single fence? Then
Yes, that part.
absolutely not correct. And normal procedure, yes, if you have retender resumption, then your wisdom would have been correct.
My lord.
Minus the retender, the person who had committed default and received your decision to terminate
My
and
lord.
received judicial imprimatur of single bench as well as division bench. How your wisdom can prevail?
My lord. That part.
That part is.
But, my
And
lord,
coercive action is already operating against him.
my lord,
That no coercive action.
yes. My lord, no, regarding that,
You
my
should
lord,
notice. But at the
regarding,
same
my lord,
time,
the
I'll
allowing,
observe now.
no, my lord, lordship will kindly consider this, my lord. Regarding the, my lord, resumption of, my lord, the work by the respondent number 6 herein, who was the edit appellant, that was brought to the notice of the division bench, my lord, in the writ appeal. That was brought to the notice of the,
Okay, I am passing the order. Single bench, division bench, at least so far as that Mansoor is concerned. We are not giving any relief to him. That one order is operating already
yes, we got,
in his favor.
yes, in the earlier.
At
pending
least he has
petition.
brought to light this fact that the authority has disregarded. At least somehow
But
he
my
could be
lord,
able to.
so far as the present petitioner is concerned, so far as this particular letter is concerned, this, my lord, cannot be a subject of challenge, my lord. Only the authority has in the last para 10 has stated that you,
This part,
yes, this is
so
the
far,
main-
so far,
ultimately
Mr. Roy,
discussing everything,
so
my
far,
lord.
Mr. Roy,
Whether this petition will be maintainable.
Para, Lordship, please.
so far, Mr. Roy, page 122. Permission will be sought. Permission will be sought. See page 122. Page 1122.
113, nahi?
122 first.
The first para, we are concerned about the first para, my lord.
No, ultimately it is
Yes. Para 1 to 3. First para says, my lord, with reference to the above letters and recent government letter number so and so, you are asked to take action and direct the contractor, Shri Mansoor Ahmed, to resume the
Which page?
execution.
The
That is
next-
page 1 to 3, 123, my lord.
1, 2, 3. Yes.
with reference to the above letters
Which
and
paragraph? Which paragraph?
para 1, my lord. Page 120.
No, you first,
Annexure 16.
you first come to government letter.
Yes. Yes. I'm government letter only.
No,
my lord.
121.
121. Yes.
Oh, that is by
Yes.
chief engineer.
That is by chief
First,
engineer.
121,
121.
everything flows from government only.
Yes. 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 Lordship has asked me to read
121.
para 2:1.
121.
121.
Page,
Yes.
page,
Uh,
page.
Page 121.
Subject is direction for resumption and
Yes.
completion of remaining PGMSY work.
And submission affidavit so and so.
Huh.
Yes.
Then paragraph 10.
10. Yes. You are also requested to submit an affidavit so and so before the Honorable Gauhati High Court, apprising the court of the factual position of the case and seeking permission to proceed with the action as per government letters dated 7/6/2005 and 7/8/2005 against Sri Guljar Hussain Chaudhary.
Come to page 60.
Yes.
That is order of forfeiture against you.
Yes.
Right?
Yes.
That is 17.6.
Yes.
Now what is 7.8?
7/8 is my
7.8 is also against you. Some allegation.
Yes.
That cancellation of original
That is my
contract
lord.
was illegal, so and so, so and so.
Notice to proceed had to be held to be illegal.
For that,
Yes.
the chief engineer was directed to file an affidavit and to seek permission because of the interim order operating against you, or operating in your favor, right? No coercive action. Just before the para 9.
Para 9 of page 122, my lord.
122.
Yes. Your lordship may read para 8 also, my lord. On careful examination of the above facts and circumstances, it appears that due to the letter of the executive engineer dated 4/11/2025, the contractor Shri Mansoor Ahmad could not resume the work despite compliance with the contractual requirements. In view of the letters dated 17/6/2025 and 7/8/2025, on the Honorable Court's order dated 11/11/2025, that is, he is referring to the writ appeal order, my lord. It is incumbent upon the Chief Engineer, Border Roads, to issue necessary direction to the Executive Engineer for immediate resumption of execution of remaining part of the work under PMGSY package number so and so by Shri Mansoor Ahmad, and to ensure completion of the same before 31/3/2026 as stipulated by the Ministry of Rural Development, Government of India, so as to avoid further financial and legal complications.
So, Mr. It boils down to one thing, page 57. What is following the procedure?
Yes.
What is that? From your, please enlighten me on it.
My lord, following due procedure, it says, my lord, in view of the prima facie finding in the inquiry report dated so and so, it is needless to state that the action to be taken has to be strictly in accordance with the law by giving a fair opportunity to the persons arraigned.
I am
Because, my lord,
taking
there
a
is such
view,
serious allegation, my lord.
whatever, right or wrong, I don't know, that this I am taking a view from page 57, first paragraph, second line. Original contract was never legally terminated. So, award this, allow him by the original contractor, Mansoor Ahmed, and which is translated in 19/8/2025, then wisdom, then to this letter.
Recent one, 19-1. And 1-1.
This page 121.
Yes, 19.
121, page 121, and followed by 123. Now, let us see. My brief is only to what extent?
Yes, my lord. Civil
That I have to see.
Yes, yes.
I'm,
The
it is not that.
prayers made is 22.
Immediate resumption is there. First page.
My lord.
Page 22.
Lordship. Prayer one, my lord.
Prayer one.
Yes.
Is there. Where is your pleading, sir?
Setting aside, questioning the letter.
Where is your pleading?
My lord, pleading at para
As on date, your professor direction and all these.
yes. Page 20, para 20, my lord. That your petitioner states that while the aforesaid order dated 3/9/2000 passed by the WPC number in force, he came to know that respondent had issued letter dated 19/1/2006, thereby directing the respondent number 3 to issue necessary direction to the executive engineer for immediate resumption of execution of remaining part of the work under PMGSY.
Para 22, that ground is not there, my lord, in the
Issue the completion of so and so, and in response to
22, Lordship will see. Petitioner challenge it on the ground that he is already protected by a order, interim order passed in 4/8/7 of 2025, no coercive action. So, my
then
lord,
para 15
whereas,
also,
my lord, the letter says that you place it before the honorable court in that writ petition by filing an affidavit and take the leave. That is the, my lord, para 10 of the letter. It is not the case that, my lord, that termination of the learning single, which has been upheld by the learning single judge, ought not to have been now, my lord, again allotted to the private respondent number 6, because it will be in violation of the learning single judge's order. That is not his case. Para 22 is
Para
sufficient.
16. Para 6. Last
Page-
last
page
5
18.
lines. Last 7 lines. Para 16 is clear.
and we have our previous petition also maybe
Yeah, 16 one statement is there.
16
But,
is
my lord, this is already a part of, my lord, these pleadings, my lord. It's there in probably in the earlier writ petition, my lord. That's why I'm saying, my lord, here the
Yes.
challenge is different. This is part of the earlier writ petition, my lord. 4778. Lordship will see 17. Your petitioner states that the honorable court by judgment. Because these particular orders are in challenge in that writ petition, my lord. Here we are concerned with this particular letter, my lord. That's why I'm saying, my lord.
2025.
19/1/26 and, my lord, 28.
Yes, Mr. It is already there.
It is there, my lord. It's pending, my lord.
In the present that latent violation of single bench,
yes, that's correct.
division bench,
That's correct.
what was deliberated today, what has been deliberated, it can be argued there.
Yes.
So that's correct, my lord, but we
And
are,
here, these two are regarding permission.
yes.
So far as this
And
decision.
to resume
this-
the work, my lord,
Ah,
the-
this, but this is subsequent, Mr. Bora, sorry, Gogoi.
My lord.
But this direction is again,
Well,
this
no,
direction
no,
to
the lordship will see page 62. Page 62 for a moment, my lord.
that
This is the
these are
order for-
already salaries now.
Yes, my lord, it
these
is
are-
pending in that particular writ petition.
page
And,
1,
my lord, when the stay was sought for this, the honorable court said that since it is a public work, court is not going to pass any stay.
Oh.
But regarding the punitive part,
Which part?
my lord, lordship will say page 62. 19/8/2025, this is the order by which, my lord, the work was re-allotted to Mansoor. And that is
Is
already 62, my lord, annexure 8. Page order to say
63.
63, I suggest, my lord.
Page 121 and 123 subsequently, madam.
No. Lordship will see 19/8/2025. Page 63. Then, my lord, will see the order passed in the writ petition which is pending, my lord, filed by the present writ petitioner.
Lord,
What has been recorded at page?
This is a separate cause of action again, 122, immediate resumption.
Yes,
Page 122,
That-
second para. And then again, immediate resumption to resume. page 123.
Yes.
Because my lord, in the earlier writ petition, no stay was granted.
Was these two letters were part of the earlier?
No, no, no.
No, I am not on that, my lord. This particular order has flowed from this particular letter of 19/8/2025, which is
Yes.
already under
It
challenge.
will be hard together.
Yes, yes, correct.
Both will be hard
Ultimately,
together.
by 31st
But
of
these
March.
are definitely part of action which have a cause of action for the petitioner to prefer it.
My lord, how there will be a cause of action for the writ petitioner? If
No.
at all, say, my lord, for the balance work, if it is allotted to the present petitioner or any third party, how that will affect the present petitioner, my lord? He has, my lord, he was allotted a work, my lord, illegally. That is, my lord, that has been, the Honorable Court has observed, my lord. And it is there in the findings. That inquiry report has not been put to challenge, my lord.
If everything is disputed, everything will be relegated to the civil.
No.
So
I was
far,
not on
so
that.
far, this
What
now,
right will be, right of the petitioner will affect, my
now
lord, if the work is.
you are in a hurry. So
Because
he is also in a hurry
No, how that will affect the petitioner?
because he is claiming whatever, legal or illegal, forged or no, whatever. He said he has done some work.
My lord?
He had done some work.
Yes.
Right or wrong, legal, illegal, forgery,
My lord,
fake, whatever.
yes, that part, my lord, page 104, Lordship will see in the order.
This direction is on the basis. My main concern is that this direction is made on the basis with an observation that never legally terminated.
But that part, of course, I am not
Are-
saying, my lord, yes.
That part,
Otherwise,
this-
my lord, the locus.
This authority is sitting over the matter over judgment of the single judge. as if
Of course,
it is
that-
nothing.
That's different.
This is I am mainly
On that
concerned
point, I am not
that
submitting, my lord.
you remove that. We have no other. But you have to do that. It's I
Yes,
have marked
that
it.
part probably, my lord,
I have
will
marked
to.
it. I'm sorry to say this observation
Yes, probably, my lord.
was uncalled for.
Proper recourse would have been taken, my
He
lord.
could have said that by taking into account since he was doing the work, so we have exercised our wisdom. But with this observation, I am on the basis of the rule of law.
Lordship.
Nothing, neither to
Of
Mansur
course,
nor
the
to
learned
this.
Singh's order is binding on us, that part.
And that has been approved by the division bench also.
But when that information was placed before the division bench, that it has been reallocated to the appellant.
Wisdom. Wisdom is different. Then court did not observe anything, division bench.
Yes.
When state was exercising their wisdom, in the recall the conciliation order and directed the so and so, and the executive, it was never brought to light.
Hello.
This page, we go by what you say, but this original contract was never legally terminated. That was not brought to light. Hard.
Hello.
Mr. J. Roy Lance, considered by Mr. D. Bora, and the counsel for the petition. It has consumed a lot of time. Mr. B. Gogoi, learned additional advocate general.
1 to 5.
Estate by anybody? Mr.
M. Bhuya, Lordship.
M. Bhuya, learned counsel for the correspondent number 1 to 5. Stuff. The petitioner in this petition has put to challenge 2 office letters dated 19/1/2026 within bracket annexer 15 and an office letter dated 28/1/2026 annexer 16. Which contain 2 observations. First of which contain 2 directions. First up by the first direction, the government in the Public Works Department directed the chief in the PWD, border roads, NEC works, Assam, respond number 3. to direct the respondent number 5 for immediate resumption of execution of the remaining part of the concerned contract work under PMGSY, package number AS-13-278 by the respondent number 6, and to ensure completion of the contract work before 31/6/2000. Full stop. By the subsequent letter dated 28/6/2026, comma, the respondent number 3 has directed the respondent number 5 in a similar manner. Full stop. By the second direction, comma, by the second direction, comma, an affidavit has been directed to be filed in WBC number 4887/2025 to apprise the court as regards the factual position of the case and to seek permission to proceed with action as per government letters dated 17/6/2025 and dated 7/8/2025 against the present by the order, by the office letter dated 17/6/2025, comma, the respondent authorities had inter alia directed for actions of liquidation stroke forfeiture of fixed deposit receipt stroke security deposit stroke performance security as EPC by the letter dated 7/8/2025, comma, allegations. It has been conveyed to the petitioner that certain irregularities have been established. Commission of irregularities of the nature mentioned therein are found established in respect of the award of the contract remaining part of the contract work under PMGSY number so and so in favor of the present petition. So, insofar as these two office letters insofar as the direction made by these two office letters are concerned, comma, an interim order dated 3/9/2025 passed in a writ petition WBC number 4887/2025, comma, preferred by the petitioner herein, comma, is in operation, full stop. Therefore, no further observation, comma, at this stage with regard to the second direction is required. Full stop. In this repeat. So interim order is operating, we need not have to comment that. Full stop. So far as the resumption, so far as the direction, for immediate resumption of the contract work is concerned, comma, the petitioner has alleged that the direction is blatantly in violation of the judgment and order dated 30/11/2022, passed in WBC number 2243/2021. Post of as the Lawrence Senior Master appearing for the petition has filed and submitted that Same is also in violation of the order dated 11/11/2025. Past tense. Read appeal number 379/2000. दोस्तों पैरा initially the contract was awarded to the respond number 6. You should notice returnable consequence steps. Respond number 6. Straightforward. You good? I'm good. Video. Contract work, the construction of and maintenance of Anipur Zamuang NEC Road to Dokhin Rampur district Karimganj. Contract work under the PMGSY scheme. Subsequently, due to failure on the part of the respondent number 6 to execute the work in terms in terms and conforming to the terms and conditions of the contract agreement, the same came to be terminated by an order of termination dated 9/12/2020. Correct or not? Please check. First off, it transpires that after such termination, the remaining part of the contract work was hurriedly awarded to the present petitioner, right? First off, with such when first off, the issues came up for consideration before a coordinate bench of this court in WPC number 2243/2021, preferred by the respondent number 6 as the writ petition. First off, on the issue of termination, the writ petition was disposed of by judgment and order dated 30/11/2020. First off, on the issue of termination, the court had reached a finding, had recorded a finding that the challenge to the termination of contract was not liable to be interfered with. So the meaning thereby, the action taken by the respondent authorities to terminate the contract work of awarded to the respondent was found out to be correct. Full stop. As regards allotment of the balance remaining work of the contract work to the present petitioner hearing, the court directed to proceed with further inquiry on the basis of revelations regarding commission of glaring anomalies on the basis of a fact-finding inquiry report dated 6/4/2020. An inter-court appeal WA number. P97/2000 in bracket to Ahmed versus the state of Assam and 6 others was preferred. Full stop. After the judgment and order dated 30/11/2022, the and comma the respondent number two in an office letter dated 5/6/2025 within bracket annex of 5 had recorded a finding that the original contract, quote unquote, the original contract was never legally terminated, unquote. Full stop. The aforequoted observation, comma, in the opinion of this court, in the considered opinion of this court, comma, was against the judicial imprimatur received as regards legality of the received in the judgment and order dated so and so, as regards legality of the termination of the contract working under reference. Full stop. In the judgment and in the order dated 11/11/2025, the Honorable Division Bench had recorded a finding that the allegation level against the appellant, i.e. the respondent of 6, was found to be correct. The Honorable Division Bench has observed that a submission was made before the Division Bench to the effect that the respondents, in their wisdom, had recalled the cancellation order and had directed the respondent number 5 to entrust the balance work to the appellant herein, i.e. the respondent number 6 herein, provide communication dated 7/8/2025. And the respondent number 6 had acted accordingly by office letter dated 19/8/2025. Full stop. Before the division bench, a prayer was made for withdrawal of the repetition. And accepting the prayer, comma, the bill was dismissed as withdrawn. Full stop. In the impugned impugned office letters, nexus so and so and so and so, direction has been made for immediate resumption of the contract for in position. So, having gone through the materials documents brought on record, comma, court has So it primacy appears that despite receipt of judicial imprimatur as regards legality of the termination order passed against the respondent number 6 in hearing, which order was passed by the state respondents themselves, comma, the award of the remaining part of the contract work in favor of the respondent number 6 hearing is on the basis of its finding that the original contract work was never legally terminated, quote unquote. So, in view of the above, comma, quote, where the court is of the concept view that the court is of the concept view that the petition has been able to made out a primacy case. On the ground that notwithstanding any, no, sorry, before that, the petitioner has claimed that after being allotted with the remaining part of the contract work, he had executed a substantial portion of the contract work. Also, the petitioner has further claimed that he had in fact completed the remaining part of the contract work. So these claims are would require factual determination. These claims made by the petition require factual determination. So because of the counterclaims of the respondent also. However, the basis to award the remaining part of the contract work to the respondent number 6 with the finding that original contract work, the original contract was never legally terminated, quote unquote, is found to be against the decision of the coordinate bench of this court as well as of the division bench. Is suggestive of an action, contrary to the decision of the single judge dated so and so, which was in currency and which received and the judgment order dated 11/11/2025 of the Honorable Division Bench. So in such view of the matter, the direction made in the impugned office letters dated so and so for immediate resumption of the contract work by the respondent number 6 shall remain in abeyance till the return.
20
Short date.
Yes, my lord, civil matter, club, both the matters, my lord.
Yes, release the case on so and so with WBC number.
4887 of 25.
You file the affidavit there.
Yes, yes.
Let it be decided
Yes.
this way or that way.
Lord, will give a date.
Do you date?
Well,
Is your pleading?
Yes, second week of March or first week of March, my lord. On 6th. Fine, my lord.
Not 6, my lord, but 6.
You agree and give it to the court master. Next.
And next is 13.
28.
Yes, Mr. Prabhu.
The petitioner was accorded the work order, my lord, in pursuance to NIT, and my name appeared at page 15, serial number 46, my lord, Titabar.
Oh, 50.
Ah.
DWD.
15, my lord, lordship, kindly
Okay.
skip page. My
Yes.
serial number is 464.
Ah.
And work order completion of
started.
the time is 12 months.
You
There are-
started
My lord, I have,
contract work executed,
yes, my lord, 50% I have,
cancellation notice.
no, my lord, not exactly cancellation, my lord, lordship will see before that, my lord, lordship
What
will
is
see
under challenge?
under challenge, my lord, annexure 5 and 6, my lord,
5.
5. May I read, my lord?
Yes, please.
With reference to the above notice, so-and-so correspondence under reference so-and-so undersigned hereby expresses deep concerns to complete indifference to repeated the persuasion of the resume the complete the work till date. You are therefore issued the earlier occasions also as discussed with the chief engineer PWD so-and-so so-and-so Titabar Territorial Division on behalf of the Governor of Assam and powers conferred under to rescind.
Gone.
Rescind.
Gone.
Thereafter, my lord, another letter was issued that your lordship will see page
Scene
30.
and final joint measurement.
Yes, my lord. They asked me, I have given 2 numbers of,
So final joint measurement was carried out.
not, my lord. It has not been, my lord. No,
Was
any
done to
notice
be
was
filed.
received about by me, my lord.
Cancellation with reference to it is to inform you that as per notice, final measurement of the above mentioned work was to be done at site on 11/11/2025.
My lord.
Was it done or not?
No, my lord. To my
In
knowledge,
this
my lord, I
regard,
have
I
not received
visited the site.
any notice. And
Following
now, my lord,
observations were made.
now, my lord, I have given one application to the authority at page 39, my lord.
No, page 38.
My lord.
Considering this above observation made during my visit,
My lord.
you are hereby directed to submit the final measurements duly signed by the contractor. This
My-
is to the assistant executive engineer,
My lord.
right?
My lord.
To the his office at the earliest and to prepare the balance work estimate.
My lord.
Your work is rescinded.
My lord.
It is only the measurement
Yes.
for 2 purposes. Maybe to give money to you and to retender. The issue same involved.
Yes, yes, earlier like one.
Right.
My lord.
So,
Here, my lord,
but-
one thing, my lord, lordship, kindly permit me, my lord, lordship, for a moment. Kindly have a look, page 39 and 40 page, my lord.
at least I have seen page 37. See the
37
reference.
Yes, my lord. Reference, I have
It
not.
was preceded by at least
I have not.
5
received-
notices.
I have not. received a
That is a
single-
matter to be decided later on.
My lord, I have made.
What
a
is your prayer now?
Now prayer is, my lord.
Joint measurement?
No, my lord. My prayer is, my lord, lordship, kindly see, I prayed I challenge to notice. And if otherwise, my lord, 6 months time is given to me, my lord.
Oh, that
I'll
cannot
complete
be.
it, my
That is not possible.
Now, lordship will
That
see.
is not possible.
Yes, my lord.
If that is the only issue, we can decide it now.
No, my lord, let them take the instruction, my lord,
P11.
what measurement,
11,
what thing they have done, whether any notice was issued to me or not, my lord, under reference.
No, that is also, Mr. Please see page 38. Executive engineer has directed the
My lord.
assistant executive engineer to make final measurement with the contractor.
My lord.
So, he will be involved in the process.
My lord, I have not been done, my lord. Why the-
So, wait.
That, my lord, measurement also, my lord, it has not been done, my lord, so far I.
If not done, you complete.
No, my lord,
Mr.
let
Bo-
them take,
my
my
lord.
lord. If they go for a, my lord, fresh tender also, it will take another long time, my lord. Better to give it to me,
Which-
my
which-
lord.
I'll cancel the contract.
No, my lord, I don't want cancel this. I
Then,
want to complete it, my lord.
that same issue, we'll fix the case with the earlier 2 cases. Whether a cancelled contractor can be given
Yes,
the
my-
same contract again.
Yes. For
A
continuation.
defaulted contractor
And
Then,
in the similar line, my lord, I got a
It will
judgment.
be poor.
My lord, I got a judgment, my lord, in the
Oh.
mobile, but I could not download it. Next day, I'll place it, my lord.
Will issue simply notice or joint measurement, Mr.
Lordship issued the notice, my
Yes,
lord,
lord.
purpose will serve, my lord.
Huh?
First, joint measurement, my lord, I will have the instruction. Probably it has been done, my lord. If
No,
he has
no, it
not, my
has
lord,
not.
cooperated, it will be expired, my lord.
Ria Bormhuya. Learning Council for the petitioner, Mr. P. Gogoi, and additional Advocate General, for all the respondents. The petitioner was, after a tender process come up, the petitioner was awarded a contract work,
Next
quote
chapter, my lord.
unquote, construction of road under Mukha Montreal, Pokipot Nirman Asoni for the year 2022-2023, page 35, for an amount of rupees 2 crore. Having a
2.2.
contract value of rupees 2 crore, 2,25,700,
2.7, my lord. Along with, my lord, maintenance.
with the allegation, with the allegation of with the allegations that the petitioner did not adhere to the timeline, etc. Notices were issued to the petitioner, and subsequently on 3/11/2025, the contract work was rescinded with, as per tender clause number 59.2, and the earnest money and security deposit were forfeited. The petitioner was informed that final joint measurement of the contract work, if anything was done, would be measured as per specifications, and on 11/11/2025, the respondent, respondent number 3 directed the assistant executive engineer of the concerned subdivision to prepare final measurement, duly of the contract work executed by the petitioner, duly executed by the contractor, and to submit the final measurements to the respondent number 3, and to prepare the balance work estimate so that re-tendering process can be started immediately. First of, agreed by the aforesaid directions, the petitioner is before this by this petition issue notice returnable on so and so, as Mr. Gogoi, we had accepted. No formal notice, extra copies. Having regard to the nature of grievances raised, it is observed that if pendency of this petition shall not be a bar for the respondent authorities to make final measurements of the contract work, if any executed by the petitioner till date, in the presence and in agreement with the petition. That will do?
Yes, ma'am. Will.
6-3.
6-3.
Pendency of the petition, Krishna.
Time being matter, item 6.
Yes.
Is it
What
last
kind
year?
of,
If this matter pertains to non-payment.
where is the statement?
Sorry, Malas. Yes,
Where is the statement
Yes, that
of
is
admission
pertinent.
of liability?
Malas, on the last
Take
occasion.
that's all.
Yes, Malas, we have filed an additional affidavit bringing in the representation.
What is the material there?
Malas may have the
If
representation.
there is nothing.
Malas, I'm only seeking directions to dispose of the representation, Malas, either way accepting it or rejecting it. That's
What kind of rebate?
Well-
This court is completely against disposal of representation order?
Well, because on the last occasion, it was observed that,
So this court is otherwise not very much interested
well,
to dispose of a writ petition with a direction to the respondent authorities to dispose of the representative.
unless may I
Right
ask
from
for-
my case, only in exceptional cases I direct, when the factual determination is not possible. Otherwise, we don't direct.
my lords,
Ah.
that
Yes,
scenario-
with some observation, if we can direct, we'll direct. But otherwise, no. Normally, we don't.
As I'm seeking a
it.
lesser relief, I'm just seeking that my representation may be disposed.
You pursue that before that authority.
My lords, in
That
that
cannot
case,
be.
I would like to argue, my lords, that I also have a separate cause of action. That is non-consideration of my representation, which I sent last year, which was actually posted to the office of the
If
chief.
there is a cause of action,
Yes, ma'am.
right, for a legal remedy, right, you may submit representation after representation. 100 representation also will not give rise to any cause of action or new cause of action. That is a law.
My
You have
lords-
to pursue legal remedy.
Yes, my lords.
Either you pursue with the respondent authorities, that is one option, or to legal remedy.
My lords-
And legal remedy may be somewhere else.
Correct, ma'am. My lords, as far
Right.
as
When
far
there
as
is
Sher Ali is concerned.
no
yes,
admission of liability.
Right, my
And
lords.
when did you execute the work?
My lords, in the
This
year
is very recent.
2020.
2022 and 2023.
Yes, ma'am.
Okay. There might be limitation.
My lords, they can dispose it of on merits. I have no objection on it.
That I am not.
All right, my lords, let me.
I have said to you repeatedly.
In that case, I will,
Then I am dismissing that petition, that writ petition is preferred for disposal of the writ.
my lord, let me place.
I, Supreme Court of, this is Chandrachud, this is Chief Justice of India. Then Chief Justice Chandrachud's order. This kind of writ petition should not be disposed of with a direction to dispose of representation. This gives birth to
My lords, I am not seeking
Another-
disposal of the petition, my lords. I'm stating is, my lords, on consideration
try
of
to
representation
have-
by a public officer, that in itself is a dereliction of duty, my lord. That is also a cause of
Okay, let
arbitrariness, my lord.
us see then your case on merit.
Yes, ma'am. My lords may come to, my lords may have the main petition.
Work order.
As the work order starts as page 33 of the main
Estimate
petition, my
For
lord.
maintenance of store yard of entire bed facility store.
17, my lord,
Keeping
17, page 17.
store materials for second fortnight of the month 2020. Estimated cost is 6,000. Then followed by next or same order, page 18.
My lords, these are separate work orders.
These are
for
separate
works, my lord.
Separate. row.
And
How many?
my lords, in total 12, my lords.
12.
Yes, my lord. And these have been executed, my lords, after the work has been completed, my lord. My lords may have a look at terms and conditions.
Sheet 3.
Terms and conditions. Point 3 says work must be executed as per specifications and as directed by the department.
Confirm work order. What are these? Page 28.
My lords, page 28, the type copy is there at page 25, my lords. This
I
is, from-
generally look at the original one.
yes, my lords. This is also a work order from the different division number 2, my lords. There are 2 divisions involved.
These are separate work orders.
Issued by a different division. Let us
Separate work orders.
Yes, separate
Nothing
work orders.
separate from this 3/3/2023.
Yes.
All are work orders.
All are work orders.
Okay. All are work orders.
So, my lords,
Okay.
my lords,
Page 33 work order.
yes, my lord.
Then this is noticed. Page 34.
34 is my notice, my lords,
Ah.
that I've sent last year in the month of July. So, my lords,
Yes.
I'll just quickly read
Request
it.
for release.
At page 35, my lords, quickly have a look, my lords. On the second para. My client has made several verbal and informal requests for settlement of dues, but has yet to receive any definitive response. In the spirit of fairness, equity, and continuing goodwill, we are now constrained to make this formal representation requesting the expeditious release of the pending payments as well as a written update on the status of the same. So, my lords, I am pleading that this particular notice was forwarded to the office of the chief engineer last year itself, my lords. So even if we go by the requirements of Tamsher Ali, the chief engineer's office was put on notice last year itself, my lords. Thereafter, there has been no reply.
Is it the mandate in Tamsir Ali?
No, I want to distinguish that as well, my lords. But right now, I want to argue on the
Then
point
have you heard about Supreme Court judgments?
regarding
Puna, Hinda and all.
regarding my lords.
Same issue.
Yes, my lords. I feel Tamsher Ali is a stricter interpretation that has been taken.
I do it. And recent one by Justice Sandeep Mehta in Supreme Court.
My lords, if I may complete my argument on this, my lord.
There is nothing admission of liability. We only proceed on the limited basis.
Yes, but-
Otherwise, if you
Well,
read Tamsir Ali, Mr. Counsel, it is limited liability.
Right.
It is for a limited occasion at that point of time. Right? All cases pending at that point of time. Please make a list of the contractors in Syria team.
Correct.
And thereafter you start paying the money one after another and exhaust the list. It is not for all times to come otherwise. Now my coordinate bench already started observing it. Without statement of liability, nothing.
I'm aware of
So otherwise, that is for that reason, I have stopped at this point of time.
all right, my lord.
Right?
All right, my lord.
Otherwise, I had also taken a liberal view. Okay, let the affidavit come from the chief engineer or whatever. Thereafter, we'll dispose of the writ petition.
Yes, my lord.
But my coordinate bench has already observed in many matters, right, that without a statement of admission of liability from the petitioner, the case is not to be proceeded with. So that is one more difficulty on the part of the court.
But my lord,
Right.
the ratio of Tamsher
Or
Ali.
otherwise, if you interpret the ratio,
Yes, my lord.
I have already interpreted everything in 25 cases,
Okay, my lord.
right? I can repeat the observations.
Okay, my lord. My lord will allow
Only
me
thing
to-
is that
Yes, my lord.
you have to approach the
So I'll
a
not
larger
argue-
forum.
I'm not arguing on that, my lords.
Right. That is why if you can make an effort, you make an effort. Just which I have observed in case of Mr. A.R. Bhuiyan. A.R. Bhuiyan, okay, no, let him
Well,
approach.
My lords, what I want to
What I have given a leeway to the petition in item number so and so that despite approaches, the respondent authority or head of the department has not yet issued a statement of admission of liability. So he has got time to approach again in view of the order observation. If you can make it, well and good. Or otherwise, civil court option is always open for you.
My lords, I have two judgments to place in this regard, if I may place with your.
Okay, if you want to decide it, right now we'll decide tomorrow because others are waiting.
My lords can give me a.
I'll be happy to hear you.
Yes, ma'am.
Right. If you can make out a case, definitely. Tomorrow
Yes, ma'am.
or
Or day after, my lords.
Thursday?
Yes, yes.
Okay, day after. Mr.
T. Milli, my lord.
Emily, on the request of Emily, learned counsel for the petitioner, list the case on Wednesday. R.R. Gogoi, standing counsel,
PhD department of
PhD,
1 to 5.
1 to 5, present. Okay, we'll hear
Congrats, obliged, my lord.
For admission, I don't know what that.
G.D. Das. None appears for APDCL. R.R. Gogoi, you are APDCL.
Worship,
You are
No,
I
I'm
may-
for respondent number 2.
respond number
Worship.
2.
petitioner here is the petition man.
Consumer complaint. Yes. What do you want to
Petitioner
say?
here is, we have a bit of instruction that this case might be infractuous, man.
Okay.
We need some time just to get the proper instruction, man.
What is the case about?
The case is about the electricity due, man.
Area pending actually, Your Honor. An oral agreement was made between petitioner.
This is the order of consumer redressal forum.
Yes,
Right.
yes.
And
The 50% amount.
why you have preferred this writ petition?
Worship, The matter is that I don't have the brief. We have to reconstruct the brief.
Otherwise, you had an appellate remedy at that point of time. Appellate remedy is before the state Consumer Redressal Commission.
My lord. Thing is
Did
that
you file any?
I need to reconstruct the brief again, my lord.
Okay, read the file day after tomorrow.
Lord,
After tomorrow.
may I give some submission? Actually, an oral agreement made between petitioner and respondent number 2 over telephone. Telephone that postpaid meter will be replaced with the prepaid meter, where rupees 12.70 paisa will be deducted each day for the area amount from the research amount.
The question is our first is jurisdiction. Adam, about the jurisdiction. After a proceeding, a judgment and order has been delivered by District Consumer Forum. Right. So a statutory appeal lies before the State Consumer Commission.
Yes, sir.
I have put a question why you did not prefer any appeal before the appellate authority. Law is settled when there is a statutory remedy of appeal is available. How can a writ petition be entertained? There is a statutory adequate efficacious alternative remedy.
Yes.
I have asked the question. He has said might become infractious. Let us see. List on the Mr.
W. Ahmed.
W. Ahmed. Your name is not there.
On behalf of B. Chaudhary, my
On behalf of
B. Chaudhary,
B. Chaudhary. From petitioner or respondent?
petitioner. Petitioner here is the,
B. Chaudhary's name is also not there.
my lord, he is the counsel of the APD.
Huh?
He is the main counsel of the APD.
You are for APDC?
I am for the
The
APD.
beach water standing council is earlier set of
Okay. Mr. W. Rahman. W. Rahman.
W. Ahmed.
Ahmed. Learned counsel on behalf of Mr. B. Chaudhary. Learned standing counsel, APDCL, has sought time till video that or how to obtain instruction as to whether there is any live cause of action. Proceed further. So Miss
M. Buraguhai.
M. Burago, learned counsel for the petitioner or respondent number 2 is as sought for by Mr. Rahman, list the key.
23rd February.
You take proper instruction regarding
Yes, my lord.
live cause of action and the second one, which I have asked you. Why you have preferred the repeat?
13. 23. Next.
G.J. Sharma. Yes, madam. Petitioners approach this in non-renewal of fair price has that is the affidavit final. Can we really produced? There is license. Terms.
Lordship, I appear for respondent number 2 and 4 in this matter, my lord. For BTC, my lord, we have already filed our affidavit. Only that the specific query was asked on the last occasion, my lord, that whether it is reasonable on the part of respondent authorities to renew without disclosing the reasons, my lord. That instruction I do not have.
Can it can be decided
Otherwise, our affidavit is filed, my lord.
because it is pursuant to an order framed under Section 3 of the Essential Commodities Act, perhaps,
Lordship.
and that has some statutory color. So,
Our affidavit is there, my lord. Our stand is
email case pending
lordship.
is one.
1.
Second is filing of charge sheet.
Yes, Shokos was
Then
also.
third is
Shokos was-
finding of guilt and conviction and sentence. Third one may carry,
Lord,
may be followed by consequential action. But other two,
regarding the present state of-
presumption, the person is, you argue before the court all day, the person should be presumed to be innocent unless proven guilty. So what do you say? What do you want?
State has anything to say, my lord, because Mr. K. Gogoi was also.
Mr. Borua is sitting tight. He is not responding.
Gosh.
Your file. Then okay. Madam, next week, Tuesday,
Yes.
proceedings complete. You want to file reply? No. Miss?
K. Bhattacharya.
K. Bhattacharya is a petitioner. Mr. S.R. Borua, Learned. Junior Government Advocate for the response number 1, 3, 4 and 6. 1, 3, 4 and 6. Miss B. Sharma.
B. Bora, my lord.
B. Bora. Learned Standing Council.
Standing Council,
PTC.
BTC. Lordship.
2,
2 and 4.
2 and 4 are present. Ms. So-and-so, Learned Council for petition has submitted that there is no necessity to file any affidavit in reply. So stop. The Learned Council for the parties have further submitted that the exchange of pleading is complete. So stop. Release the case. Keep up. Release the case. So-and-so
24
for admission
24-2.
in the admission column.
God bless you.
You come prepare. No, that's good. Yes.
Lordship bills
UK
amounting to
Director
rupees 5 lakh
Communication, UK Director Standing Council Panchayat. Instruction issued to him by way of. What kind of dispute?
Lordship, we have supplied some materials, Lordship.
Yes, Miss Bora.
Lordship already sent a proposal to the finance department
From the department.
for sanction of the amount through FIN Assam, to the FIN Assam portal. We have already sent a proposal to the finance.
So,
Lordship, there is finance department is not a party here in this.
is it a necessity?
Lordship, because sanctioning authority is the finance department.
Okay, where have you stated any affidavit?
Um,
Simple, verbal, all these things, then after it will be turned out that no.
Lordship. We'll
File within 1 week.
Lordship.
Without fail,
Lordship.
otherwise cost of 5,000. We have received instruction.
Lordship.
File it.
Kindly.
Then only we will.
Kindly 2 weeks time may be. 2 weeks time may be given. Lordship.
Without fail,
Lordship. Lordship.
otherwise adverse observation. Okay. As the petitioner, Miss N. Bora, Standing Council Panchayat and Rural Development Department for all the
For respondent number, Lordship 1 and 2.
1, 2, S.R. Borua, 3 and 4. Ms. Bora has submitted that she has received the necessary instruction and the affidavit in opposition would be filed invariably within 2 weeks' time. This is the case on so-and-so. So stop. It is further observed that in the event no affidavit in opposition is filed on or before the return of next date of listing, the court will proceed for determination for to give consideration to the repetition on the basis of the materials on it.
Publish.
Item 15.
And full stop. And not for non-filing of affidavit, a cost might be imposed.
In this matter, pleadings are complete already.
What is the case?
Petitioner is the association of
Huh?
fair price of dealers. One meeting was held. The CM was the chairman, and it was
Okay,
held that
everything is complete. Okay, next Monday, we'll make an endeavor. Today is sort of time. Next Monday or take him an and get petitioner.
Not on Monday, Lordship. Lordship will fix a date, Lordship, after 2 weeks.
Right, you. Learn it.
Yes, Lord, for state law.
For all the state response. As the pleading, exchange of pleading is complete, the case.
6
Right. Hearing, okay, here. Okay, fixed. Then we'll proceed.
17. Item number
Kaskar Bora. Yes, Mr. Deuri.
Your Lordship, this matter relates to non-payment of bill, Your Lordship.
Non-payment. Of their state counter? No.
They filed
Ms.
a,
Gayan?
I have filed, my lord, in item number 22, my lord, I have filed one affidavit in opposition, my lord, for the same matter, my lord. If that comes under the same scheme, my lord, that will cover all the case 17, 18, and 19, my lord.
Okay. Then today is positive time.
yes, yes.
Yes, my lord.
Silent next week or Kumbar. E. Deuri. Petitioner again, Central Government Council for the state response. Yes, you were there. Yes. Tin Lung, right?
Yeah.
Standing Council on behalf of Arandas. Yes. Standing Council. Okay, so Ms. Gayan has submitted that the counter affidavit filed in
Item number 22, my lord, WPC.
22.
Yes, WPC number.
of
Yes, my lord.
Pierre Padgiri's case.
Yes, my lord, that is my,
Mr. Deuri, have you received copy?
No, Your Lordship.
And
I have already.
but my,
That-
he'll be handicapped.
Yes, no, he will provide me one.
yes, my lord.
He is not a petitioner there.
Mukut Ranjan Sharma. Yes,
Pierre
sir.
Padgiri is the petitioner.
Oh,
Council. You furnish a copy
yes, I'll.
to
Yes,
Mr. Deuri
Deuri also, my lord.
by within 2 days.
Yes, my lord. Definitely.
Right.
Yes, my lord.
Then he can come up whether he needs to file any reply to counter. Right? Okay, where is Mr. Padgiri? Item 22?
What 20?
You are there for a petitioner. Oh. Okay. WBC number 5520/2024 would also cover the case of the petitioner hearing. MS Gayan has undertaken to serve a copy of the said affidavit in opposition counter affidavit to Mr. Deuri by Prohi. Full stop. Same likhi dibo. You give one copy.
Yes, ma'am. I'll give
Similar
mine.
order in 18 and 19. Right. And list the case on Wednesday. Huh? 18, 19, 20, right?
No, 17, 18, 19, Your Lordship.
Okay, 17.
Very grateful.
SK Deuri. Yes.
Hello. Yeah, in this instruction was called for.
Yes, Mr.
Lordship, we have received the instructions and we would like to file our affidavit.
Okay, within what time?
Lordship it's a voluminous affidavit. Lordship may give us 3 weeks time.
Okay, SK Deuri, Learned Counsel for the petition is present. Mr. M. Bhuyan, Learned Counsel, appearing on behalf of the respondent PWD authorities, has sought for and is granted 3 weeks time to file the counter affidavit as he has submitted that he has received the necessary instructions. First of place the case on.
Much obliged, Lordship.
Let it be on 13th.
Much obliged, Lordship. 21.
There is no representation on behalf of the petitioner to be on call. Mr. R. Gogol, Learned Standing Counsel, Excise Department, is in attendance. You have not representation, commanded the case for ensure justice be listed after 2 weeks. It will. Same. It will be on representation. You list the case of so and so date. No. There is no representation on behalf of the petitioner today on call. Let the case come up for ensure justice be listed on cases 17, 18, 19,
25 to.
Mr. C. Borua, Standing Counsel. Okay. Accountant General is in attendance.
Item number 29.
Manjit Borua. Same 2 weeks, could you? Oh, Mr. Arago, 29. Yes, madam.
Please, your lordship. Lordship, we may be allowed to file the additional affidavit.
Okay. Miss, your name, please.
J. Goswami.
And council has sought for further, what time?
Lordship, 2
2,
weeks.
3, 4,
2 weeks.
2 weeks to file an additional affidavit. Okay. Miss Arbora, pending us on chat. Is present.
N Bora.
The prayer is allowed, please.
N Bora.
And Bora. Prayer is allowed, list the case on.
11-3. Item 31.
Yes.
Maybe fixed on any other date. Otherwise, instruction was called for, Lord.
We have received an instruction, Lordship.
Filing affidavit or instruction is enough?
Lordship, some instruction are sought for the status regarding his renewal of the arms license. So we have received that instruction regarding having some criminal cases. Yes, cases. So
Criminal
otherwise, it
case,
can, on the basis of the instruction, it can be, Lord. Can we fix on a next date, Lordship?
Sir, Sharma. Is- Your name is
Behalf of
not
J-
there?
On behalf of J.I. Borga.
SJ.
SJ Sam.
SJ Sharma. Okay. Learned counsel has appeared on behalf of the petitioner, Mr. Saburo, learned legal advocate, appeared for the state responsible submitted that he has received instructions. Pusto, and has sought the listing of the case on another date. It is the case on I have that date.
Obliged.
32.
Yes.
This case pertains to the illegal seizure of trucks. On the last occasion on 9 January, the matter came up. The court. Yes. Silent. Why they were the seizure of the trucks for so long? Accordingly, I have a copy today afternoon. I need time to go through.
So in fact, my lord, the vehicle was not allowed to cross the border because there was some verification process was going on. In fact, the vehicle has been already released. Vehicle has already crossed the border. There is no live issue here. On 9/1, Lordship has directed the senior SP Okrajar to file an affidavit stating the reason why it was my lord, the vehicle is not allowed to cross. We have filed the affidavit. In fact, the SP has also made an inquiry, and my lord, because of if Lordship, the affidavit is on record. The inquiry was done by the additional SP headquarters. She has, my lord, in the detail, my lord, from the authorities during the verification process, it took some time. We have in the detailed inquiry report we have annexed. In the affidavit, we have also
Let
said.
him go through it.
If required, we'll file an affidavit also.
Otherwise, my lord, the issue is already taken care.
Okay. Or Mr. R. Sharma, learned counsel for the petitioner, Mr. D. Nath, learned advocate for the state. The affidavit in opposition on behalf of the respondent number 4.
But it's an affidavit
Filed
compliance with the honorable
to
court.
the order dated
9/1.
2020.
9/1/26.
Is on record. So Mr. Sharma has sought some time, but has submitted that he has received a copy of the affidavit today
Today afternoon.
and has sought for some time to go through the same and to file an affidavit in reply, if so advised. On the other hand, Mr. Nath has submitted that there is no live cause of action. Proceed further hearing. Release the case on it to next party. Aji ki bar aji. Monday ba Buddha ba. How much time you need? 7 days. 10 days. Next Friday, next Friday.
26.
27.
27. 26. Lordship. Obliged, your Lordship.
Item number 23 for orders.
Yes, 23. What is this? 1 minute.
Have directed us to our LCR, Lordship have directed us to reconstruct our LCR, lower court record. Our Lordship, as it was mid, but there was no instruction regarding the LCR from our. So we need another time.
1 minute. Record is again.
So in this case, reflects that the HT has misplaced the LCR Lordship. Hereafter, we also try to check with
Who
client
has misplaced the LCR?
from case.
Huh? No. Answer. Eduki.
Case note 13/9/2002.
Yes, what to do?
Yes, Lord. I also tried to contact with client and ask them to come to party Lordship because this matter is before my joining at bar Lordship. And the learned senior counsel SN Sharma who required Lordship. By response side also we not find out the record.
There is an order for reconstruction. The workman can also, is possible, or otherwise you have to reconstruct. You may have the domestic inquiry, perhaps. Otherwise, you have no option. But there is 17B or something like that is complied with or not. Huh? 17B?
17B,
It comes here or no?
oh, Lordship, they have not filed any application because 17B Lordship, they have to file
So
a
their application is required nowadays. Dictum has changed perhaps. Because a quality learning for the petition has sought further 3 weeks time to obtain instruction whether it is possible to reconstruct, whether find out whether the petitioner is in possession of the records, including the deposition of witnesses, and to reconstruct the record therefrom. Straightforward. After 3 weeks, partial piece of
24.
yes.
Well, the direction of the honorable court is to verify and verify the entitlement of the petitioner and to pay the amount. Well, we have verified, we have filed the affidavit. Out of his claim, well, he claimed 53,96,000. We could verify, well, according to us, payable amount is 35,81,000. And well, the process has been initiated. Now they said that soon, well, the ceiling proposal will be submitted. Kindly give us some time, well, it will be paid to him.
What you try to do, whatever FOC or what, until 20th March?
Lordship.
ABT. Talk, petition. The dinner submitted that I'm paying for the Council paying for the
Full
full
response.
response. The sanction for an amount of rupees 5 lakh, 81,325
325.
has been made, and the matter is being processed further for receipt of sealing or FOC.
FOC.
FOC. Here's what received on the case after 4 weeks in order to obtain further instruction command. This is the of 2002.
26.
Yes, Mr. Roy.
19th of January, I have deposited 36 lakh, 50% of the assessed APDCLB. I have deposited on 7th.
Let it before another bench.
I have deposited
No, release the case before any other bench will join.
Entry may be extended, Lordship.
That will, I will not extend immediately. Immediately, as Mr. P. Royal and is to release the case.
Supplementary list, item 33. Yeah, please, Your Lordship. If the office note, last office note states that the respondent number 2 and 3 have been duly served, my lord. And moreover, the Dasti service was also taken on. The
Which
respondent,
affidavit?
Lordship, Dasti service affidavit was also filed.
Mr. M. Sawalal, learned counsel for the petition is present. First of, leaves the case before the Lodging Court for a report as regards service of notice upon the respondent number.
2 and 3. My lord, Dasti service was also filed.
We don't,
Lordship.
I don't do the clerical thing.
Lordship.
For a report, as regards service of notice upon the
Respondent number 2 and 3.
2 and 3, leaves the case on.
Interim order is.
Leaves the case on so and so, interim order partially continued.
Lordship.